All right, Joseph Tartakovsky is the author of The Lives of the Constitution, 10 Exceptional Minds That Shaped America's Supreme Law. Joseph is also a contributing editor of the Claremont Review of Books, a great review. If you don't get it, you should, and a former associate at the San Francisco office of Gibson, Dunn, and Crutcher, where he focused on criminal defense, complex civil litigation, appellate briefing, and constitutional law. He has written for the New York Times, the Wall Street Journal, National Review, Los Angeles Times. We had a really good talk about the Constitution. Here it is. All right. Joseph Tartakovsky, thank you for being here. It's good to see you.
Great to see you. Thanks for having me, Andrew.
So your book is called The Lives of the Constitution, 10 Exceptional Minds That Shaped America's Supreme Law. Why The Lives of the Constitution? Explain the title.
I wanted to tell the story of Americans' journeys under the Constitution. We've had 230 years now, longer than any people on earth, and most constitutional histories are a series of Supreme Court decisions or theories of the Constitution. But the story of the Constitution is the story of the American people. So I picked 10 people who made extraordinary contributions in one way or another, from before the founding to the present day. And they all came from very different places. Scottish immigrants like James Wilson at the founding. I have a black female journalist who was at her peak in the 1880s, 1890s, all the way to Scalia. And so very different circumstances, but they all show in various ways how we've overcome our constitutional challenges over the centuries. And the lessons are important because I find that these same clashes keep reoccurring.
The same clash. Okay, well, we'll get to that in a sec. But let's start before the founding. You mentioned what's his name? Wilson, is right? He's one of the more obscure people that you talk about. Who is he?
Yeah, undeservedly so. So James Wilson is the most important founder that people haven't heard of.
Huh.
He's one of 6 people that signed both the Declaration and the Constitution. He was the driving force at the Constitutional Convention with Madison. He was the first founder to publicly defend the Constitution after the convention. And he gave a famous speech that became the most cited document in the ratification debate. And he wrote something called the Lectures on Law, which was the first sort of constitutional law course under the Constitution, and is just as good as the Federalist Papers. And it's the most searching examination of our American political philosophy as it relates to the Constitution.
It's always seemed to me almost providential, the level of the minds that were present at the creation. I mean, that were present at the founding. Is there something besides the hand of God that you think created the kind, like you talk about Alexander Hamilton, that brought those people together at that particular moment? Was there something in the American sauce that made that happen?
It seems that way because this extraordinary, I mean, how the concentration of talent that you had during this period is, I mean, to me, it seems like it's something like 5th century Athens, or London under Elizabeth, or Florence under the Medicis. I have some friends in the Texas governor's office that have been calling officially for a new constitutional convention. I say, if you can get that many great people as we had during that era, then I'm for it. But you're never going to have that again, ever. That's
just what I said this on the air the other day. We have this thing called The Conversation where people send in questions and you answer them live. And somebody asked about the Convention of States. And I said, yes, I'll do it as long as we can have John Adams and Thomas Jefferson and, all the rest. But people have been yelling at me ever since because they say, no, because of Mark Levin is very big on this. He loves this idea. But he says because it takes so many states to ratify, it wouldn't become a Belgian waffle of like our Constitution would come out as 1,000 pages regulating the salt that goes into potato chips. Do you agree with that? I have to ask because you bring it up and I'm in this kind of firefight about it right this minute.
It's too risky. The Constitution has served us. The Constitution has served us so well. We've entered our 3rd century under the Constitution. Why tamper with it? And it's not just they were learned individuals, but between the time of the Declaration and the Constitution, the American states had ratified 17 different constitutions in the states. So what these people had in particular was experience in creating constitutional orders. And that's what they brought to Philadelphia. They had experimented. So Benjamin Franklin had created a constitution. He was the chair of the Pennsylvania Constitutional Convention. Their Constitution of 1776 had a 12-man executive. So the president of sorts was a city council. So people thought that was a good idea, but they tried it. It didn't work. People had experimented with unicameral legislatures. So these people brought this extraordinary experience in knowing what works and what doesn't. And you could definitely not replicate that today.
So we're talking about the book, The Lives of the Constitution, 10 Exceptional Minds That Shaped America's Supreme Law by Joseph Tartakovsky. Let's move on to the Civil War. You talk there about Daniel Webster, a guy whose name he was very famous when I was a kid, but we never hear about him anymore.
Yeah, I tried to pick some of these individuals that did contributed to our constitutional understandings, but have sort of been lost. Daniel Webster was the chief protagonist of the most important constitutional debates in the first generation to follow the founders.
Okay,
and that was a very big deal for him. He felt that his father's generation, his father had been had guarded George Washington's tent, among other things. They bequeathed us this amazing document, and he was his whole adult life was just filled with anxiety that his generation was going to be the one to fumble it away. I mean, we've been one generation, so he was involved in all the great fights about nullification, whether a president like Andrew Jackson can ignore a law he doesn't like, whether the Supreme Court is supreme as the expositor of our Constitution, and it's a body of constitutional thought that is still so useful. And he was cited, Daniel Webster's arguments were cited 12 times in the briefs in the fight over the Affordable Care Act. So you see how these fights perpetually recur.
Yeah. The left is always hitting on the Constitution, partly because many of the founders owned slaves. And secondly, of course, because of the clause that was meant to keep the southern states from using slaves as a population ballast, essentially. What is the Civil War baked into the Constitution? Was the Civil War baked into the founding? Was it inevitable?
Yeah, so I wouldn't use. I feel like at the founding, the consensus was that slavery was a bad thing that had to be dealt with, and they didn't know how to deal with it. Now, some of the founders were confirmed slave owners and were unwilling to give up the institution, but a lot of the guys at the convention were not. I mean, Franklin, Hamilton, John Adams, these are key people. I think that the struggle, something seemed to have changed in the 1820s, 1830s, where the South started defending slavery as a good institution. I mean, not something that they had to figure out a way to extirpate, but something worth defending. But I explore that question. I mean, whether it was inevitable. Daniel Webster was responsible for the last attempt, the Compromise of 1850. You know, California comes into the Free State, the Fugitive Slave Clause is bulked up. This was like the last exit I can see, attempt to solve this legislatively. So, yeah, it may be, but you never know with these historical things.
That whether they could have been avoided or not. I mean, yeah.
So it's fun to think about. But
one of the guys in this in the Lives of the Constitution is Alexis de Tocqueville, a writer who seems to have been right about everything that he said. I mean, it's a kind of bizarre. You can go back to read him, and there's not a false note in anything that he said. What was he able to see that Americans weren't able to see? Why was his vision so clear?
It's an extraordinary thing. I mean, you have this 20-something-year-old Frenchman. He spends 271 days in America and then writes what is considered. He came here with a skeptical eye. He thought that democracy, the spirit was coming to France, and he wanted to know what to make of it and how France would adapt itself. But I do sound a few notes of dissent to the consensus.
Okay.
Because here I compare Tocqueville to Bryce. James Bryce was a Scotsman, but he came from the United Kingdom, and he came about 40 years after Tocqueville, and his goal was to displace Tocqueville. And for a while, his book American Commonwealth was a rival. Now we forgot about Bryce, but I find in many ways Bryce was more accurate, because Tocqueville was very good on American culture, but he didn't care all that much about our institutions and our legal institutions. He doesn't say that much about our Constitution. He doesn't say anything about American literature, universities. He doesn't talk about these emblems of early Americanness like railroads, banking, manufacturing. So he did, I think, miss a lot about America, and what he missed is particularly tied to the way our constitutional framework influences how Americans behave.
Yeah. You talk about Woodrow Wilson. I was talking about him earlier this week, what I guess will be last week when we play this. This idea that the a Constitution was, as FDR said, a kind of horse and buggy document, that it was no longer suitable for the 20th century, that it limited the president from being the big man, as Woodrow Wilson would say. Was that a new thought, or had that been there from the beginning? Was that a germ that was just kind of coming to fruition with Wilson, or did he bring that out of nowhere?
Well, I find that on the question you asked about whether the Constitution prevents the president from being a big man, Woodrow Wilson's very interesting on this point. I'll give you one example. Thomas Jefferson stopped the practice of the president going to speak to the Congress in person. He said, "This is what kings used to do in England, and I won't do it." And so 24 presidents followed Jefferson, and Wilson was the one that shattered that. He went to Congress to speak in person in 1913. And his argument was not that the Constitution is outdated, but his argument was, first, as a textual thing, the Constitution does say that the president shall from time to time recommend measures to Congress. So the president has the role. Congress, by the way, flipped out when he came. They said this was a violation of the separation of powers, an illegal attempt to influence legislation. And Woodrow Wilson's other argument was historical. He said, George Washington came to Congress. John Adams came to Congress. This was a good thing. And so it wasn't as much a departure as you think. And I find that happens a lot. So supposed departures from the past sometimes are actually revivals of old and better traditions. I mean, we wouldn't have the State of the Union as we know it if Woodrow Wilson or someone after him hadn't, they used to submit the thing in writing. And there were like 40,000 words, there were little books.
But it does seem to me that Wilson and FDR felt unfairly constrained by the Constitution in ways. I mean, I know that Washington was a strong executive and believed in a strong executive, but it does seem to me that Wilson and FDR had a new idea of the executive power. Is that wrong? Am I wrong about that?
No, I think you're right. And Wilson wrote 2 books as an academic making that point that the president had to be stronger. But what I find, I think the best way to look at it is not that Wilson thought that the Constitution as framed made the president too weak. What he was arguing against was the separation of powers as practiced in the 1880s and 1890s. And this was a time of incredible congressional dominance. The Speaker of the House, guys like, they called him Czar Reed, Joseph Cannon, they were more powerful than the president. That's why no one knows the names of the presidents between Grant and McKinley. I mean, right. they were water boys for Congress.
Interesting.
And so he thought actually, well, at least in his view, the separation of powers was imbalanced in a way that departed from what the founders thought. At least the founders that he admired most, which were Washington, Hamilton, the nationalists, the presidential power guys, maybe not so much the Madison and Jefferson. So he thought there was something to correct there. Now, whether he was right about, it's clear that we've gone to a president that is something that was no one thought he was going to be that powerful, because the founders were actually very worried of executive.
Yeah. Well, now let's finish up in terms of the people with Scalia. I mean, I think we all remember the day that he died and feeling that something truly terrible had happened. That really something that the election that we were in had suddenly become much more high stakes. What was it about Scalia that made him so special? I think he was the greatest jurist of our generation. Okay.
And there's just the brilliance of his opinions. But the reason I gave him the last word and what makes him so important today is because he was the chief voice for sounding the alarm to Americans about the way that the United States Supreme Court, in decision after decision, is constitutionalizing questions that had been for the people to decide. social questions, military questions, welfare, free speech, religion, national security. I mean, he thought this was undermining self-government almost imperceptibly. And he thought it was very dangerous, and I agree with him.
Yeah,
that is the constitutional imbalance that we have today, the power of the courts, in particular the federal courts.
You said at the beginning of this that at the beginning of our conversation, you said that there are certain themes that have continually played out through the history of the Constitution. Can you name a couple to tell us what they are, what we should be looking at as we go forward that they're going to be arguing about?
Just to take what's in the news, say take war powers. You know, who is empowered in this country to get us into military conflict? It seems to have been the consensus that Congress would play a very large role. Congress does not play a very large role. So the president today was tweeting about we might strike Syria, maybe now, maybe later. I'm not sure it was quite their view that the president was the one to sort of call the shots just on his own. But we've come that way not so much as a matter of, I mean, the Constitution itself, the text hasn't changed, but the practice has changed. So presidents have called American troops into war something like 150 times without congressional approval or ratification. And so Congress has sort of acquiesced, and that has become essentially the constitutional law. Is this question of that we were talking about with Scalia of constitutionalizing ordinary questions that should be for the people? Is that something you see going forward? Is that fight going to continue? Yeah, it will continue.
Yeah.
I'll give you an example of that. So for Scalia, the ultimate example of the court doing this was the death penalty. The Constitution authorizes it, and the court was just chipping away. And last month, the president said there should be the death penalty for drug dealers. And a lot of eyes rolled on the left in particular. I don't think the left would be would be less eye rolling if they knew the decision that actually makes the proposal unconstitutional. And there's a decision from 1977 that said that you cannot execute someone unless they themselves take a life. The issue in that case was whether you can execute someone for rape. And this was the court's reasoning. They said, for the victim of a rape, life may not be nearly so happy as it was before, but it is not over, and surely it is not beyond repair. In other words, rape is just not that big a deal. Death it's just too much constitutionally. Now, our culture is changing before our eyes on this point. I mean, people think sexual assault is a much bigger deal than 9 elderly gentlemen did in 1977 on the court.
Uh-huh.
And so I do find that Americans are willing to think about their Constitution. They don't accept the verdicts of the Supreme Court always, like take Roe v. Wade, for instance. Mm-hmm. So, yeah, some of these fights will never go away. And I think Scalia's warning is I want to do my part to carry that forward.
The Lives of the Constitution, 10 Exceptional Minds That Shaped America's Supreme Law by Joseph Tartakovsky. Joseph, thank you very much for coming on. Really interesting conversation.
Thank you, Andrew. Great to see you.
I'll see you again.